Please call the list.
Item number 1. Mr. Shishanna Bandyopadhyay is appearing in online.
The personal appearance was directed, Muller.
Who is for the petitioner applicant?
Muller, the order under contempt is at page 107 of the contempt application, Muller. So appearing at two places, one of them is at page 107. And the operative portion starts from page 109 bottom, last two lines.
Not order dated 13th September 2023.
Yes. But it's appearing at two places in the brief.
It is at page 98.
Or at 98 and 107, both places it is there. If your lordship is taking 98, the operative portion is 100 bottom.
Just a minute.
100.
Now, what was the decision taken by the authority?
Muller, the authority, Muller, this was delegated to the senior special secretary. The delegation was allowed under the order, Muller. And Muller, the order has been passed that the petitioner was not engaged against a sanctioned vacant post on or before 1st of April 2010, and hence no benefit can be granted to the petitioner. That is the order passed, Muller, and it has also been communicated in the meantime to the petitioner.
What about the direction that the petitioner will also be given remuneration on a monthly basis as per the applicable memos?
Muller, that was to be considered, Muller. Muller, the direction was that it shall consider the representation within a period of 3 weeks.
Part of the direction that the Secretary, Department of Panchayat and Rural Development Affairs, Government of West Bengal, or any other authority delegated by above the position of
original order, the main order,
has taken such decision.
Muller, it was delegated to the senior special secretary who has passed the order.
And this other part of the order, if the representation or the contention of the petitioner is allowed, in that event, petitioner is entitled to get the arrears salary in terms of the memorandum dated 26th February 2016.
Since it was not allowed and rejected,
now your contention is this, that the order has been passed on consolidation of the representation, negating the prayer of the petitioner since petitioner was found not eligible. But what about the other part of the direction that the petitioner will also be given remuneration on a monthly basis as per the applicable memos?
No, my lord, that in my humble submission, my lord, it is with regard, this paragraph is with regard to in the event it is found that the petitioner is entitled to the benefits of the memo dated February 26, 2016. And my lord,
Your submission is that this part of the order depends upon the decision to be taken by the authority.
Taken. And my lord, now the decision having been taken and the order having been communicated, they
In
a
terms
fresh
of
cause of action.
18 September 2023.
My
Now,
lord.
what about the delay?
Now, my lord, this order was communicated to us on 22nd of September. A hearing was fixed. The hearing was given on 1st April when the petitioner appeared, my lord. When the last occasion when the matter appeared before your lordship, my lord, perhaps the petitioner did not apprise your lordship that they had appeared before the hearing. And on that day itself, my lord, the order was passed. There was, my lord, I admit there was a gap of, my lord, about leaving aside the puja month, my lord, there was a gap of about 4 months, my lord. There has been that delay, my lord.
13 September order,
Yes,
according
my
to
lord,
communicated to the authority when?
22nd of September 23.
22nd September, if it is to be counted from 22nd September, then October, November, December, in the month of December, the period expired.
Yes, my lord. My lord, there has been some delay, my lord, with regard to that, my lord.
Very well pay cost of 50,000 rupees, Mr. Bandyopadhyay.
Mulad, it's Mulad, the today, Mulad, the order having been Mulad, complied, Mulad. There's only a delay of 2-3 months, Mulad. If necessary, we can file an affidavit, Mulad,
The fact
justifying the delay.
It is not the fact that on the first day the rule was issued, there was a direction to issue notice. Notice was issued to the department, to the contemner. In that event also, last occasion, he was not represented. Finding no other alternative, court had to issue a rule.
No,
And
Mulad, but as far as the Mulad service is concerned, Mulad, we have tried to, as far as the second service at least is concerned, we have tried to ascertain that service, Mulad. If we, Mulad,
where is the order?
your lordship.
Where is the order passed in terms of the order dated 13 September 2023?
Yes, Mulad, Mr. Singh kindly hand it over, Mulad, to. Mulad, I am making submission, Mulad, with the leave of my learned senior, Mr. Sen, Mulad, because I find he has reached court, Mulad.
Discussed in details, Madam, with regard to all those memos which was indicated in the order itself. And after that, my lord, the final order comes.
Issue. Rule was issued on 19th April 2024 against the alleged contemner.
May I just, my lord, my lord, it appears from, my lord, the documents produced, my lord, the document required from.
Stop. Today, the contempt application is heard, heard, and it has been specifically submitted on behalf of, specifically it has been submitted on behalf of the alleged contemner, that the order passed by the coordinate bench on the connected writ petition dated 13 September 2023 has been complied with. Ordered what is the date of the order? Video order dated 1st April 2024. Passed by the senior special secretary, to the special secretary, to the government of West Bengal, Department of Panchayat and Rural Development. Stop. Copy of the said order dated 1st April 2024 is placed before this court and the same is taken on record. However, court having seen the order is not satisfied with regard to strict observance of the directions as contained in the order dated 13 September 2023 with regard to the delay caused in passing order since the order was passed by the coordinate bench on 13 September 2023 directing the authority to take decision within a period of 3 months, but the order was passed on 1st April 2024. Stop. Next paragraph. In terms of the rule, now In view of issuance of rule against the alleged contemner, the said contemner is required to appear before this court in person. But
Malad, he is already appearing, Malad.
but considering the order passed on 1st April 2024 by the Senior Special Secretary to the Government of West Bengal in terms of the order dated 13 September 2023 of the Coordinate Bench, and the alleged contemner has entered appearance during the course of hearing on virtual mode. Personal presence of the said alleged contemner, based on the rule issued on 19th April 2024, stands dispensed with for the time being. Next paragraph. The alleged contemner is directed to file affidavit of compliance by 1 week after ensuing summer vacation, explaining the delay caused in passing order in terms of the directions as contained in the order dated 13 September 2023. Stop. List the matter under the heading New Contempt on 21st June 2024.
Well, personal.
However, it is made clear that the alleged contemner is not required to remain personally present on the next day.
It's not.
Grateful, Malad.
I am disposing of your recalling application.
Yes, Malad, that has become infructuous, Malad.
আর একটা line add করো.
Can one.
In view of the order passed today in the contempt application, the recalling application taken out by the alleged contemner, being Can 1 of 2024, stands disposed of.
Grateful, Malad.
আচ্ছা, একটা লাইন উপরে শুভেন্দু অ্যাড করে দেবে, টুডে নো ওয়ান অ্যাপিয়ার্স ফর দ্য অ্যাপ্লিক্যান্ট। Item number 2.
Lord, I beg to appear on behalf of petitioner.
What your justice directed on.
Just a minute.
Yes.
Yes.
You are filing this melody. Melody was said on 5th of April that the 20th.
Just a minute. The issue I have formulated by passing order dated 5th April 2024.
That is.
Just I want to go through that order. Yes.
But although in the petition for contempt, he has not said that whether the pay which has is received, my lord, whether was on the basis of 20,170 or my lord 18,810, and my lord whether the withdrawal amount which has been mentioned in the order of the on a single bench, coordinate bench, whether it has been my lord recovered by or withdrawal has been recovered or not. Although it has not stated, but your lordship was pleased to my lord direct us to show that the payment has been made on the basis of my lord 20,170. My lord, I have from December my lord, 2015. My lord, I have given my lord the document to show that my lord the pay my lord has been made my lord on the basis of 20,000 my lord 200. It is 170. Your lordship can see my lord page my lord 22. Then I have given a chart.
Yes.
That my lord the basic pay and jet pay together with that my lord 18,170. 20,170.
That's 16,570 and 3,600.
3,600.
That comes to
20,170. And on the basis of that, my lord, whatever that TA and HRA and all these things, my lord, that has been paid. This is my lord 2015. I have given my lord some of the
so that
documents.
is that pay is required to be allowed to the petitioner from 1st December
Yes,
2015.
yes, 2015.
So this is the salary bill
July-
which
July
you are
2015.
showing, that is to 11 July 2015.
And next year, you can see my lord, the
But
December-
it is 11 July 2015. Yes, next page.
next one is 2016.
Yes,
That
yes,
is also my lord, increase after the increment was given.
yes,
17,360. Then the total comes to my lord 41,500.
yes.
Then you can the next document. 24, well, that is from 2017. That is also there is an
Same.
increase,
Incremental benefits were added and it
And-
was enhanced.
and,
And it was more than 20,170.
yes. Then, my lord, I have given a chart, my lord, that from the serving group that even lordship can see, my lord, that regarding the Shomita Hall, in the meantime, my lord, the pay benefit was given to the Europa 2019. That is, my lord, from January 2016. That benefit was also given to him. That has been recorded. And my lord, the year wise, my lord, it has been mentioned. After multiplying 2015, your lordship is equal to 2.57. Then it comes to 51 lakh, 51,840. Then onwards, my lord, 16, 17, 18, 19, 20 to 23 has been mentioned.
Yes.
But that has been
And
mentioned.
it appears that after multiplying 20,170.
Yes, sir. And where the so far as the overall amount is concerned, my lord, it has not been, my lord, it has been refunded, and I have not, my lord, claim for that.
Deducted.
No.
Now, where you have stated that?
ওখানে লিখেছি আজকে নাই এটা দিবি যে টাকাটা না Eligibility C ballot, that paid ballot 5. G. No withdrawal amount was recovered from the petitioner.
Yes.
And no
Yes.
pay scale has been
Lordship,
reduced.
kindly,
by the
my lord, I have not got the copy of the same. I have not scope, my lord, I have got no scope. But my lord, from the payslip, my lord, which I have brought, my lord, in
You
July
have to
2000,
you have to demonstrate on the basis of the pay slip and the chart which has
Right.
been annexed to this affidavit.
my lord. My lord, I have to demonstrate. Lordship, kindly, my
No,
lord.
what is your instruction? Till date you have not been paid.
Statement whether he has got.
My lord, if you
Are you sure? I will prolong the hearing, but if I find that it has been paid, then you have to face the consequences.
my lord.
Others are mentioning every day for
lord,
inclusion of
my
the
lord.
content
My
matters.
lord, I can show on.
Today's clear picture has been given by the municipality. In spite of that, you want if it is your instruction that he has not been paid, And ultimately, if I find
My-
that he has been paid,
My lord,
then at least
my lord,
be ready for payment of cost.
my lord, lordship, kindly, my lord, allow me, lord, to give a reply, my lord, because, my lord, I have, my lord, come with the pay slip. In July 2019, my lord, my basic pay was given 19,130. And, my lord, from the pay slip of August, it will appear it has been reduced to 17.
Make up your mind. I have satisfied my conscience.
My lord, my lord,
I
lord
have
will also
satisfied
be-
my conscience. Now, if according to these are the forged documents, then question would have been different.
Yes.
Very
Because-
well. Very well. You
my lord,
use
if
your
that will be clear, my lord, from
use
three
your
documents.
you use your affidavit.
My lord,
Then if I find, then be ready for 50,000 cost.
17,500. Against, 19,130. That has been reduced.
You use your affidavit, but if I find that this is a wrong contention, be ready for
Kindly give me a
50,000
chance,
cost.
because I have to go through the same.
Give a copy of the affidavit.
My-
Please see, come to page 22.
20,
Yes, page 22.
20,
2. Salary bill for the month of July 2015.
my lord,
See the first and the second column of the table.
my lord,
Basic pay and grade pay,
my lord.
16,570 and
Hello.
3,600. It is above 20,170.
My lord.
So what further is required?
But, my lord, if your lordship kindly consider this pay slip.
No, I will not consider. This pay slip is being considered, is annexed by the authority
But,
in
my
their
lord,
affidavit.
but,
Is it a false document?
but, my lord, I have to see, my lord, whether this document they have annexed. My lord, in 18/7/2019 pay slip, I was given, my lord, 19,130. And, my lord, in August, that has been, my lord, reduced to 17,590. And I have retired. I have
Show me your place. Yes, I understand.
Lordship, kindly.
Yes,
Together with that, my lord, the
must be. Basic pay is to be
added with the grade.
added with the grade pay.
Lordship, kindly consider this one.
Yes, 19,130 plus 3,600.
And next month, lordship, kindly consider.
17,590.
That has been
Is
reduced.
telling with this document.
My lord, lordship, kindly give me a chance.
No.
Give me a chance to
No.
go through it.
No.
Otherwise, I will not be able to.
17,000, just a minute. Same document.
17,000, my lord, that has been reduced. From 19,000, it has been 17,000. And till the date of my retirement in January 2004, I have received it.
24th August 2019. 24th August 2019. 27%. 26. 18 July 2019. July 2019. You add 19,130 to and plus 3,600.
Right.
Yes, and calculate that
No,
it is,
lordship, kindly,
it is less than 20. No, it
Lordship,
is,
kindly
it
give
is
me a
less.
chance, my lord, to
in a
come in the
no,
next
no,
week.
court will not refix the court will not refix the pay.
But
You add basic pay plus grade pay.
my lord,
It must be above 20,170.
my lord, it was 22,000.
Yes, then
730.
then
And my lord,
you show from any of the document which you are relying upon that the pay, basic pay and grade pay is less than 20,170. Yes.
my lord, in my lord, July 2019, my lord, I was paid, my lord, 22,000.
20,170 কোথাও আছে কিনা দেখা
My lord, in my lord, July 2019, my lord, I was paid, my lord, 22,730.
Then
And
it is
below-
it is higher than 20,170.
In August, my lord, it has been reduced to, my lord, 21,090.
Yeah, that I am not concerned. I am concerned whether 20,170
Yes.
less than 20,170 was paid to you. With regard to calculation, this contempt court will not exercise its jurisdiction. Because what was the order?
But to kindly consider. Page 29.
Yes, this order has been defined elaborately in my order.
My lord.
Just a minute, come to
5th April.
5th April. Please read it loudly from the third paragraph.
Lord, Mr. Alok Kumar Ghosh, learned advocate representing alleged container, submitted that by virtue of the order dated 22nd September 2020.
No, prior to that, there is an order on 1st March 2025.
March.
Yes.
1st March order, is not with me.
1st March 2025. Read it. Dauto. Read it loudly. Read it so that we can also.
My lord. Affidavit of service filed on behalf of the
Third paragraph.
third paragraph. On perusal of the order dated 21st August 2019, it appears that the alleged contemner downgraded the pay of the petitioner from 20,170 to 18,810 with effect from December 2015, and in the scale of pay 17,700 to 37,600 with grade pay of rupees 3600. Today, the learned advocate representing the alleged contemner submitted that he has to take instruction whether the pay which the applicant was enjoying prior to issuance of the order dated 21st August 2019 is restored or not. The order was passed by the coordinate bench on 22nd September 2023, causing the order dated 21st August 2019. Let the contempt rule be issued.
That is the issue.
My lord, issue was that
For your understanding, please read it again.
below grade pay, my lord, 3,600.
Yes. Yes. That is the order because that order was set aside. 21st, keep the papers to me. In contempt jurisdiction, you cannot get your pay fixed higher. That is not the periphery of the contempt jurisdiction.
But my lord, so far
Just a
the
minute. From 1st December. What is the order dated 21st August 2019?
First, I have,
That which was set aside by the coordinate bench?
I have given announcement here. My the
Affidavit.
affidavit of compliance. My lord.
Page.
21st August 2019, that is case 12.
is 12 months.
And
Just a minute. Just a minute, just a minute.
জয় সাহেব বুঝে তার জন্য আলাদা
Now, Mr. Ghosh, what was the basic pay of an upper division clerk at the relevant point of time? Because if you come to the order dated 21st August 2019, come to page 2.
21st August 2019.
Please place it.
The undersigned has been pleased to appoint Srimati Shobita Haldar on promotion to the post of EC tax collector in charge from the post of tax collector with effect from 1st December 2015. On post facto basis with the usual scale of fee and allowance as are addressable to her from time to time under relevant government orders on the basis of the post facto approval accorded by the director local bodies West Bengal under its memo number such. Accordingly, her basic pay will be fixed from 1st December 2015 at rupees 18,810 in the scale of pay of rupees 7,100 to 37,600 with gate pay 2,600.
So therefore, this order was set aside.
These are set aside.
This order set aside.
Sir, and next
Now,
order- and
you have
subsequent-
now there was this order was passed. The relevant order was passed by the coordinate bench based on the direction contained in the order of the honorable division bench.
Yes.
That order of the honorable division bench is quoted. Come to page 28 of the order.
28.
Yes, 28 of the contempt application.
We therefore direct the appellants to grant the benefit of higher scale of upper division clerk with the respondent discretion or while discharging the duties of tax collector.
So,
Tax collector.
yes, not tax collector, upper division clerk.
Right.
The scale of upper division clerk was required to be given to the petitioner.
Yes.
Now, the scale of what was the scale of the upper division clerk at the material point of time?
Page 21 also can cap to my position.
Yes, page 21.
Payment 3, my lord. 7,100 to 37,600.
Payment 3.
7100 to 37,600. And 300, 600, if it is added, then it comes to that.
Now, why in the basic pay, the grade pay is to be included? Why in the basic pay, grade pay is to be included?
That is part of the system. That is the
Because the order,
when the grade pay is given, and so it into both ballot, it is considered that is the initial pay. And they ballot, whatever the increments, that should be ballot given.
But 21st August 2019 order, which was set aside by this court, accordingly, her basic pay will be fixed on 1st December 2015. 18,810 in the scale of pay of rupees 71,007.
That is ballot.
37.
That was our
So basic pay of 18,810 with grade pay of 3,600.
That was our decision, but that has been set aside. That has been taken, accepted by the decision by the
Now, in view of the decision, the pay fixation which was made on 1st December 2015, that is 18,810 plus 3,600 as grade pay, how this was altered?
Even yearly come next document will yearly come to 12 September 2019, which was for set aside at page 13.
That is the consequential order in view of downgrading the pay overdrawn amount. I'm not asking this.
No, that is what specifically mentioned.
What I'm asking,
3,117.
Mr. Ghosh, on 1st December 2015 is the date which is to be reckoned. 1st December 2015, the pay of the petitioner was fixed rupees 18,810 as basic and grade pay 3,600. Now show me that after the order passed by this court, what was the alteration made in order to grant higher benefits on 1st December 2015?
That was made clear. I will of course, as you know,
in your pay chart, which pay fixation, which you have drawn attention of this court, come to just a minute. Yes, that is the bill dated 11 July 2015. Now, 1st December 20, just a minute, 1st December 2015. Just
but two documents has been set aside. 12 September also they set aside. That was part of the specifically mentioned that what would be the pay 20,170. Instead of that, that has been mentioned.
just a minute.
12 September 2019.
11 December 2015. 17,180. First come to page 23.
23.
Yes.
23 of my lord, my opposition.
Yes. Today's affidavit.
23, yes, my lord.
This is the payslip for the month of December 22,
July.
December 2016.
December 2016.
Yes.
December 2016.
Yes, sir.
Now, where is the payslip of December 2015?
15.
Yes.
July, I have given the July 2015 at page 22.
Yes. Why not December 2015? Because in the order dated 21st August 2019.
Continued, this continues,
So according to you, the pay structure which was existing on July 2015, that remained up to June 2016.
up to his retirement.
Very well. Then come to page 22.
22.
11 July 2015.
22. That is 11 July 2015.
Yes, 11 July 2015. In 11 July 2015, your basic pay was 16,570 and grade pay is 3,600.
Both.
Just a minute. Now the order dated, come to tally this document with the document which is at page 12.
You're taking 12 and 30.
Please come to page 12.
Yes, sir. 12.
Please come to page 12.
12 my lord,
Accordingly, her basic pay will be fixed on 1st December 2015 at rupees 18,810 in the scale of pay of rupees 7,100 to 37,600 with a grade pay of rupees 3,000. So therefore, after this order was set aside. This order was set aside.
my lord.
And there is a requirement to upgrade the pay of the petitioner from 18,810 to 20,170 on 1st December 2015. But your document at page 22 shows on 11 July 2015, which existed up to June 2016, the basic pay was 16,570 plus grade pay 3,600.
My lord.
So therefore, the order which was passed on 21st of August 2019, whereby grade basic pay of the petitioner was fixed at 18,810 and the grade pay 3,600, that was turned down by the court.
Under the code, my lord, that what would have been? That would have been, my lord, 20,170. That is revealed, my lord, from next document. You have the next document, my lord.
বলছি এটা গ্রেড রসা কি বলছি
18,800 প্লাস 3,000 হবে।
No. এটা স্কেল অফ পে
কত হচ্ছে?
ইনক্লুডিং হবে এটা নিয়ে।
কি মামলা হবে না?
রেট পে এটা হচ্ছে পেব্যাক।
There is no change in the memo dated 12 September 2019. It is a
Says, my lord, instead totally.
it is reiteration of the fixation which was made on 1st of December 2015
Yes.
with a direction to deduct or refund the amount of rupees 4,85,035.
Oh my, it says, my lord, 18,810 with effect from 1st December.
Same thing.
Instead of 20,170.
That is the replication of the memo dated 21st of August 2019, and both the memo was set aside. So where is the enhancement?
There is no question of enhancement.
Yes, that is the purport of the order by the Honorable Division Bench, based on which this court. Now it appears even after even both the orders were set aside, one dated 21st of August 2019 and another dated 12 September 2019. There was no enhancement because it has specifically been held that I have also, having considered this entire gamut of the issue, found that there was a requirement to upgrade the pay of the petitioner from 18,810 to 20,170. 18,810 was the basic pay on 1st of December 2015. That was set aside by the court.
Right.
Mr. Ghosh,
Yes.
if that is set aside, then his pay should have been enhanced from 18,810 to 20,170 on 1st of December 2015.
20,170 has been given.
Prior to that, yes.
That has been given in what manner? Please apply your mind. Come to page 12 again. Please come to page 12 again.
Page 12.
It is not the correct fixation. It's a very short document. Come to the last sentence. Accordingly, her basic pay will be fixed on 1st December 2015 at rupees 18,810 in the scale of pay of rupees 71,000, scale of pay of so with grade pay of rupees 3,600. Now,
Scale of pay. This is scale of pay with grade pay.
basic pay was 18,810 in the scale of pay of rupees with grade pay of rupees 3,600.
উইথ গেট পে এত হবে এইটা করতে হবে সেই জন্য
এটা কি বলতে বেশি প্লাস গ্রেড পে মিলে হচ্ছে এই পে ব্যান্ড 7,800 থেকে 3,700 তার সঙ্গে 3,400 এটা হচ্ছে পে ব্যান্ড টোটাল। আপনার স্টার্ট হচ্ছে এইভাবে এই 17 দিবেন 17 UD post or ND post scale of
And this has been further clarified. You will get further clarification from the next page, page 13. Mr. Ghosh, come to don't be swayed by the prompting of your junior. Come to page 13. Next page.
I'm trying to understand.
Yes. Both of us are trying to understand. Come to page 13. Page 13, first paragraph. Then issued by the director of local bodies, government is a approval. It's not very relevant. Then what is relevant is your basic pay has been fixed at rupees 18,810 with effect from 1st December 2015 instead of 20,170 in the scale of pay of rupees 7,100 to 37,600 with the grade pay of rupees 3,600. So therefore, 18,810 with effect from 1st December 2015 instead of 20,170.
That was done.
That was set aside.
That was done.
Thereby, meaning then it comes to a situation where his basic pay should have been with effect from 1st of December 2015, 20,170 apart from grade pay.
Apart from
Yes,
pay.
yes,
Right, sir.
yes.
But this-
Because if your contention is accepted that the element of grade pay is included in the basic pay of rupees 18,810, then there would not have been any further enhancement of the basic pay with effect from same date. That is and it was found that it was 20,170.
My lord is my lord observing that this 20,170 together with
Add 18,810. $18,810 plus 3,600. Please add
My lord.
18,810 plus 3,600.
Hmm. 22,140.
22,140.
20,
21,410. 21,410.
22,140.
100.
40.
21,410.
$18,810 plus 3,600.
So 3,000, therefore the grade pay of rupees 3,600 has no nexus with regard to fixation of pay, basic pay. In that event, there will be no difference of the amount of that as it has been indicated in memo dated 21st August 2019 on 1st of December 2015, which has been found to be 18,810, and in the next page, it was found to be 20,170. Because if grade pay would have been included, then it would have been 22,140. So apart from grade pay, what was the amount which was payable was 18,810, and that was confirmed in a subsequent order dated 12 September 2019 that no, you are not entitled to the basic pay of rupees 20,170. Rather, you are entitled to get 18,810 along with the grade pay of rupees
My lord
3,600.
is observing that 18,810.
I could understand the situation or I could have appreciated your stand had there been if it is found that on adding 3,600 to 18,810 it would come to 20,170. That is not the case.
Because he was observing that.
That is not the case.
18,810 plus 3,600.
Yes.
Well, let me well, understand the ideology takes it up after some time. Well, let me well, make point clear. Then you'll.
Come to the order passed by the coordinate bench by versus Saraf, where the order of the division bench has been quoted. Page 28.
In the content.
Page 28. We therefore direct
Second post.
The appellate hearing to grant the benefit of higher scale of upper division clerk to the respondent petitioner who are discharging the duties of tax collector. However, the said respondent petitioner cannot be appointed to the post of head clerk of the municipality at this stage, since the said post has not yet fallen vacant and presently occupied by section number 6.
So therefore, we are therefore direct the appellant to grant the benefit of higher scale of pay of upper division clerk. And in a contempt proceedings, your municipality has furnished undertaking that upper division clerk in connection the petitioner would be granted the benefit of higher scale of upper division clerk in compliance with the order passed by this court.
That undertaking was given.
But there has been complaint. Well, I'll come and make it further clear to you, my lord, that whatever the points, my lord, now.
You take it back.
My lord. No, in addition to that, I'll make my point.
No, you file a composite affidavit. I am not satisfied with the explanation because perhaps the authority, municipality was under the impression that the basic pay includes the great pay component. That is not the fact.
3,600.
Now, Mr. Ghosh, if you tally both the two documents side by side, page 12 and page 13, first it has been said 18,810 with great pay 3,600. Subsequently, it was found that no, it is not 21,170, but it should be 18,810 with great pay of rupees 3,600.
But in the first document, it says that 18,100 in the scale of pay such and such with great pay 3,600. That scale of a pay, my lord is concerning that 18,100, how it has come? 18,100 plus great pay.
Today, the pay chart which you are showing, it goes to show that the authority is trying to do this, that this great pay component is being included or is being added to the basic pay. That is not the purport of these two orders.
No, that is also saying 18,100 plus great pay.
Great pay remains constant, 3,600. Great pay remains constant, 3,600. But the basic is fluctuating in view of the decision. Now, in the first case, the basic was found to be payable, that is 18,810. In the second order, it was found that it is payable not 20,870, but 18,810. That stand of the municipality was negated by the court by setting aside both the orders in view of the undertaking furnished by the municipality before the Honorable Division Bench in a contempt proceedings.
They need to give the pay 18,100 plus 3,600.
Yes.
What?
Yes, 18,100 plus 3,600. Now, this 18,800, that fixation was turned down by the coordinate bench. And the subsequent order was this, that 20,170 was reduced to 18,810. But that reduction was also negated because meaning thereby petitioner was entitled to get 20,170 plus great pay of rupees 3,600. Take it back.
Having regard to the decisions of the court, if he is entitled, there is a
Yes,
to
yes.
pay the amount. But let me understand what is the position there. Of course, my lord. That is
Very well. Since I have considered this affidavit, I am keeping this affidavit on record. File a supplementary affidavit clarifying the fixation because I am not satisfied with the explanation. Don't hear him. He knows everything and he will misguide you.
He wants to discuss if
He
it
knows everything. Take conference fee and hold conference on hourly basis.
Before preparing the affidavit, my lord, I have
The
made
corridor.
conference.
Conference are always on the corridor.
Otherwise, today being misled, I would have disposed of the contempt application.
No, no.
That would have been wrong on my part.
No, no, of course, my lord, but
Grateful, my
All of the chamber
lord. Let my learned friend remain, my lord. One matter has been called on.
Yes. The contempt issue. Contempt application is heard at length in presence of the learned advocates representing the applicant and the alleged contemner. And the alleged contempt. Stop. On behalf of the alleged contemner, an affidavit of compliance has been filed today and the same is taken on record. Mr. Ghosh, learned advocate representing the alleged contemner, has tried to persuade this court based on the pay slips of the petitioner in order to clarify that basic pay was allowed to the petitioner, to the applicant at the material point of time, strictly in compliance with the order passed by the coordinate bench on the connected writ petition being dated 22nd September 2023. Stop. Next paragraph. However, on perusal of the relevant documents annexed to the affidavit of compliance and hearing learned advocates representing the parties, this court is not satisfied with the explanation. Stop. It is found that the applicant is entitled to receive pay scale of our division clerk. That might have been the reason for setting aside the two orders, the two memoranda dated 21st August 2019 and 12th September 2019, whereby attempt was made to downgrade the basic pay of the petitioner, thereby demanding refund of excess drawn amount. Next paragraph. Mr. Ghosh, representing the alleged contemner, has prayed for accommodation to file a supplementary affidavit of compliance explaining the situation. Now, supplementary affidavit compliance to disclose whether basic pay which was whether basic pay of upper division clerk was allowed to the petitioner or not, allowed to the applicant or not at the material point of time. Stop. Let such supplementary affidavit of compliance be filed by 1 week after ensuing summer vacation. List the matter under the same heading for further consideration on 21st June 2024.
2 weeks. 2 weeks. After 2 weeks.
I will forget the calculation.
no,
You are getting you are getting 2 weeks in the midst.
Grateful.
No.
Item number 3.
Lord, I am for the petitioner, my lord. As per your lordship's direction, my lord.
Takes steps to join financial.
Please, what is the contempt?
My lord, kindly see the order, my lord, in our page.
Yes,
See, my lord.
explain the act of contempt.
My lord, that executive officer Puncha Panchayat Samiti by under date such and such had forwarded the name of the petitioner as daily rated casual contractual worker, was engaged in 1991 as Gram Panchayat Secretary of Thiruti Gram Panchayat to the DP and District Panchayat and Rural Development Purulia. The District Magistrate Purulia had sent the list of casual daily rated contractual workers to the Joint Secretary. My lord, Government of West Bengal, Department of Panchayat and Rural Development Department for financial and other benefit of casual worker, my lord. The said letter was communicated to the petitioner that 15/3/2017 District Panchayat and Rural Development Officer Purulia wrote a letter to the Joint Secretary Panchayat and Rural Development Department, had sought for information of present status of earlier communication in respect of financial benefit. All the letter, my lord, that is, my lord, submitted in report of, my lord, report, my lord, that unless the sanction in respect of financial benefit is received from the competent authority, Panchayat and Rural Development Department, West Bengal, of financial benefit cannot be awarded, my lord. In favor of the petitioner, the financial benefit of the petitioner is also pending due to non-sanction of by the competent authority, my lord. Kindly see, my lord, they have submitted report, my lord. Huh? Lord, their report, my lord, they have filed report in form of affidavit, my lord. In terms of, my lord, memo dated 2016, at least, my lord, I am getting
Yes.
In compliance with the said order, my lord, the instant matter has been placed before the Panchayat and Rural Development Department, my lord. And after careful consideration and in accordance with law, my lord, it was revealed, my lord, that the each Gram Panchayat establishment has only one sanctioned post, my lord, of secretary, my lord. And as per a report from the district, in this instant case, my lord, the sanctioned post of Gram Panchayat secretary was not vacant at the very relevant point of time, my lord. When the
But whether these issues can be considered, because it's a contempt petition.
Lordship,
Come
but
to the
Lordship,
page
kindly-
21 of the
Lordship,
contempt.
kindly come, once, my lord, at page,
Considering the submission, please read the order first.
Lordship, I have read. What are the concerns?
I direct the Joint Secretary, Government of West Bengal,
I direct-
to take steps for to grant financial benefit
Financial benefit.
in favor of the petitioner in terms of the memo dated 20th May 20 as well as 25th May, in accordance with law within 6 years.
No, Lordship, we have considered the matter and in accordance with law, it has been.
There is no direction for reconsideration of any taking any decision.
Grant in accordance with law. It was in.
Have
the
you
order.
filed your affidavit of affidavit explaining affidavit of compliance?
No, my lord.
Whether any affidavit of compliance has been filed?
No, nothing, my lord. After
File your affidavit of compliance. That what steps you have taken?
from 2017, they have not taken any steps, my lord. Now 2024, they are telling that I am not entitled, my lord. In terms of 2016,
Affidavit of service filed on behalf of the applicant is taken on record. Alleged contemner and alleged contemner. You are representing which contemner? You are representing which contemner?
Milord, hear me, Lord. The
Yes.
containers, Milord, implemented are not the.
You are representing which? I am asking Mr. Ms. Mukherjee. There are 3 or 4 contemners.
bolo contemner number 1.
The joint secretary is continuum number 2, my lord, but here, my lord, continuum number 2
No, no.
is.
What are the contemners, Mr. Ghali, you are representing?
Milord, may I respect, Milord, hear Milord, the.
You need not elaborate. Please, please indicate that the contemners whom you are representing.
Milord, the container I am representing is not implemented in the part in the array of parties, Lordship. Lordship, may I just refer to the last paragraph?
Who is representing? Please, I have heard Joint Secretary Government of West Bengal.
Yes.
Joint Secretary Government of West Bengal is contemner number 1. Alleged contemner number 1.
As on date, Milord, that particular post does not exist. That's why the additional secretary has given the compliance. Additional secretary, Panchayat and Rural Development Department has given the compliance, Lordship. If I may refer to the last paragraph of my report.
Contempt application is affidavit of service. Contempt application is heard in presence of the learned advocates representing the petitioner, representing the applicant, and additional secretary.
Additional secretary.
Joint secretary, additional joint secretary.
Joint secretary post is not there.
Yes, my lord, additional secretary.
Additional secretary, Department of Panchayat and Rural Development.
Panchayats and Rural Development Department.
Department of Panchayat and Rural Development. Stop.
He will give the compliance.
It has been submitted on behalf of the additional secretary that at present the post of joint secretary is not there, and the appropriate authority is the additional secretary. Stop. Leave is granted to the learned advocate representing the applicant to amend the cost title of this contempt application and implead additional secretary, Department of Panchayat and Rural Development, Government of West Bengal as additional alleged contemner in course of this day. Stop. Next paragraph. The additional secretary, Department of Panchayat and Rural Development is directed to file an affidavit of compliance explaining the steps taken in terms of the order dated 20th March 2017. Stop. Let such affidavit of compliance be filed by 2 weeks after ensuing summer vacation. Stop. list the matter under the heading old contempt in the monthly combined list of July 2024. Next.
June, my lord, any day, my lord, from
Sorry.
2017, my lord, he is
Next,
suffering,
next,
my
next.
lord. হ্যাঁ আমি একটা করে দিই আগে
Item number 4.
This is my application.
Who is representing the alleged contempt now?
Lordship, I beg to represent the alleged contempt, Lordship. Lord, there was a direction, my lord, to pay compensation as per the Fair Compensation Act, my lord, 2013, my lord. Now, my lord, state preferred an appeal. In the appeal, my lord, I find an order. It is MAT 973 of 2018, where it was said that section 24 of the 2013 interpretation, my lord, was lying before the constitutional bench of the Honorable Supreme Court at that point of time. So that is why it says, my lord, in view of the order of the Honorable Supreme Court in so and so, whereby the high courts were requested not to deal with any cases relating to the interpretation of or concerning section 24 of the Right to Fair Compensation Act. The matter stands adjourned till disposal of the reference made to the now this reference has already been disposed of by a constitutional bench in the year 20 in the development, Lordship, no, in the development. So now, my lord, I am now in a predicament as on date, this position of the my lord, I am not well aware of. Kindly give me some time so that man, because
Now, what was the interpretation of section 24?
section 24, it says, my lord, that it will not have retrospective at the moment. I don't.
Therefore, it supports the case of the applicant.
No, I'll have to, my lord. At the moment, I don't, my lord, remember the proposition.
This appeal that they've preferred before the revision bench is being dismissed for default 4 times. Four times that appeal was dismissed this one. So now they have to.
Now the appeal has been dismissed for
Yes,
default.
yes, it has been dismissed.
Not only dismissal, I'm just giving you lordship the update. Even I find one order dated 9th January 2024, which I find FMA number 161 of 2018. That means MAT 2018 might have become FMA number 161. I find, my lord, there is representation of the state, including myself. Now, report filed by the learned
Whether
legal.
the appeal is pending or appeal is dismissed?
No, also, I need some clarification. Kindly give me some time, my lord, because lordship, what has happened, because in between something has happened.
Affidavit of services
কিন্তু এখানে
filed on
appeal
behalf of the
disposed of বলে
applicant and
দিয়েছে। এই
state
কথাটা তো আমি কালকে রশ্মিতাকে অনেকবার ফোন করে
paragraph
দেখেছি।
Mr. Khali
ধরনের নাম তো দিল্লি ছিল ও এয়ারপোর্টে ছিল তাই
the alleged contempt now.
এইটা সুশোভনের মধ্যে সবগুলো এটা
Alleged contempt
দিতে ভুলে গেছিল
has prayed for accommodation to obtain instructions.
Lordship.
Next paragraph lists the matter under the heading old contempt or under the heading under the same heading in the monthly combined list of June 2024.
Lordship.
Very well.
Grateful to Lordship.
Come back with definite instructions
No, Lordship.
and the position of law as on date.
Item number 5.
My lord, in this matter, I'm appearing on behalf of the petitioner.
Yes.
On the last occasion, my lord has adjourned the.
You
Oh,
are in
sorry.
item 7.
Oh, I'm so sorry, my lord. I'm in 7. I'm so sorry.
This is your. This is not yours.
No, no, no.
My goodness.
এই যে মামলা করছিল বাবা
কাকে দিবি ওকে দিচ্ছিস কেন এখানে রেখে দে কোর্ট অফিসারের কাছ থেকে নিয়ে তো বাইরে দাঁড়িয়ে আছে
বাইরে দাঁড়িয়ে আছে
Yes. Who is for the applicant?
মারাটা
Why you did not appear on last occasion? I had to direct upon the learned advocate representing alleged contemner to serve notice upon you.
তুই আসিস নি তোমার she was তোমার deal মারা
You are for?
But I don't know for whom I am appearing. Kindly see the cost that who is the contemner I have to ascertain. There is no contemner I find.
Yes, alleged contemners.
Kindly see. Whom should I represent? I don't know.
my lord alleged containers are the my lord
Who?
2 and 3 but it was
They are
not
the
incorporated in the
Withdraw it and file a phase 1 or add someone.
my lord I can add some let me add
কোনো contemner নেই
আমি কি আর দিচ্ছি দাদা যারা দিয়ে দিচ্ছে আমাদের তাদেরই কি বলবো বলো হুম
Issue. At the time of call, the learned advocate representing the applicants has prayed for leave to amend the cause title of this contempt application in order to array the alleged contemners. Stop. In order to array the alleged contemners. Stop. Next paragraph. Leave is granted to the learned advocate representing the applicants to amend the cause title by Tuesday next, 21st May 2024. Stop. After the amendment is carried out, the learned advocate for the applicants is directed to serve notice upon the upon the newly implemented alleged contemners, enclosing copy of this contempt application and the order passed by this court by 1 week after ensuing summer vacation, and file affidavit of service on the urgent date. Next paragraph lists the contempt application under the same heading on 21st June 2020.
It
has not been properly drafted. This is
Malam.
Item number 6.
Item 6, Lord, I beg to appear on behalf of the alleged contemners. Lord, all steps have been taken. And Lord, the MIC, Lord, I have handed over a copy of the status report. Lord, Lordship, kindly say it as Joseph Kiddin. Lord, it was sent to Lord, the finance department. MIC has already Lord, sent the file to the after giving approval. Lord, only Milord.
What was the direction?
The direction was, you will find from the contempt itself that, yes.
Only Milord, your Lordship, Milord, though Milord, I am tendering and confident apology, but Milord, only Milord, your Lordship, it will take only 1 or 2 weeks time. Milord, let it be Milord 1 week. I have requested my land friend. 1 week after vacation.
I don't stand in
Appointment.
approvals with regard to, in fact, Lordship,
In connection with which posts?
Group D post.
Group D post.
Which department?
Milord, that is Milord,
Polytechnic.
hostel. Hostel. Milord, some of them retired. Milord, the financial benefit they will get. Milord, Lordship, kindly Milord, give us. But I will not trouble to your Lordship, Milord, but being an officer of the court, but I am ensuring that,
Where is the, in which page is the, just,
my lord. By this time, my lord, I believe, my lord, everything will be done, and I'll will come with the, my lord, the full compliance report in full. We have sent the file, and the file has been sent by the MIC also to the department after giving approval. Everything is ready. My lord, finance, my lord, will accord the approval accordingly. Page 8 and 11. Right.
9 candidates are there. 12.
And in fact, that has been forwarded.
Well, everything has been forwarded.
You will
Every
find the
steps have
same
been taken.
R4.
But I will not take alibi of that. But my lord, this is my duty to come with him, the fullest compliance. My lordship, kindly, fix it 1 week after vacation. By this time, I believe, my lord, that I'll ensure, my lord, I'll come with the compliance.
Issue.
And my lord, a copy of the
Last
status
occasion
report has already been given.
Mr. Banerjee, last occasion also same prayer was.
No. Simple. At that
Prayer
point,
was made
no, at that point of time, my lord is correct. But I will not take, my lord, take any alibi for that. But only, my lord,
26th April.
no, finance,
2024,
my lord,
the
it was,
contempt application
file was
taken.
kept with him, my lord,
When you appeared, your name is there.
my lord.
You appeared.
But
I remember that
Lord,
you did not appear.
but what I am, Lord,
And he prayed for time.
I am tendering unqualified apology because, my lord, being an officer of the court, I cannot play with the foul game with the court.
How much time is required?
My lord, only, my lord, 1 week after vacation, Lord, so kindly, my lord, fix it.
And in fact, this is a statement in paragraph 11 of his complaints. To be honest.
And my lord, I have already told.
Contempt application is taken up for consideration in terms of the order dated 26th April 2024. When Mr. Swapon Banerjee, learned advocate representing the alleged contemners, has prayed for some more time to comply with the order passed by the coordinate bench dated 2nd May 2023 on a connected writ petition. On the connected writ petition. Stop. Next paragraph. Considering the submissions made on behalf of the alleged contemners, hearing of this contempt application stands adjourned till 21st June 2024.
I'm deeply obliged.
In order
I'm
to
deeply
enable the alleged
obliged to
contemners
lordship for accommodation.
in order to
Please
enable
comply,
the
I'll come with
contemners
it.
to comply with the directions as contained in the order dated 2nd May 2023.
I'm deeply obliged to lordship. Well, status report be kept with the record. File today will be kept with the record.
Next paragraph. A status report has been filed on behalf of the alleged contemners.
No,
And the same is taken on
Right.
record.
21st June, yes.
21st or
21st June.
21st.
21st.
Right.
I'm deeply.
Next.
For accommodation, lordship kindly pardon.
Item number 7.
Lord, I appear on behalf of the petitioners.
For the alleged contemners, my lord.
Not on the last occasion when the matter was taken up, your lordship had adjourned for the reason there is an appeal which has been preferred by my learned friend and the state of West Bengal. Now, subsequent to that, matter was heard, the appeal was heard by the division bench, where we have given an undertaking that we will not proceed with the contempt petition till the disposal of the appeal.
Where is that order?
I'll hand over, my lord. There is an. Yeah,
It was heard by the circuit bench.
Yes, my lord.
Division bench.
Division
cited by
bench.
Justice Shom.
Yes, Showman. Kindly takes page 6, para 25, my lord.
Issue. The learned advocates representing the parties to this contempt application have jointly placed before this court the order dated 26th April 2024 passed by a coordinate bench, and the same is taken on record. Stop. Considering the observations made by the Honorable Division Bench in paragraph 25 of the order dated 26th April 2024, hearing of the contempt application stands adjourned. Stop. This stands adjourned till disposal of the appeals. Stop. Let the contempt application go out of list with liberty to mention after disposal of the appeal.
Kindly keeps a copy of the order.
Yes, I have recorded.
Very little. Grateful.
Correct. It had taken
Item number 8.
Ask me to serve Don Bosco.
ওয়েস্ট বেঙ্গল বোর্ড তারপরে ইউ হ্যাভ সার্ভড অন ডন বস্কো
এই যে আইসিএসসি তে চলে গেছে আমাদের আসলে এটা ক্যান্সেল এই আন্ডারে যেটা বেনিফিটটা চাইছে পরিশোধ আছে মধ্যে যে ইনস্টিটিউশনগুলো হেলার আছে তার মধ্যে ও করছে
কি করার জাস্ট একটু যাবে কি ঘুরে চলে আসছে
এই নোটিফিকেশনে বেনিফিট চাইছে সেই ইনস্টিটিউশনের ডেফিনেশনে ও করছে
When service was effected, Mr. Banerjee? When service was effected?
No, ও এসে করছে না
Given the affidavit of
He's born now.
they are appearing.
But here he is.
and for the contempt
You are for the Don Bosco?
Don Bosco school man
Baksagas.
no
Now, my query to the school, whether any of the teachers
No, my lord, no,
in
my
the
lord,
school
never.
are getting pension.
no my lord never
I knew that Mr. Bandyopadhyay was very much exuberant.
The question is whether anyone getting is not. If Malad, I'll make two submissions. Malad, I'll not just enlarge my argument. Malad, this is of
But
order of
again,
2000.
before he starts, Malad, I will make a very,
Yes, yes.
very embarrassing Malad submission, Malad. But in the event your lordship is hearing of the matter, but kindly does not hear it out today. That is the only thing, because I am just being inducted, Malad. Your lordship just saw, Malad, I am being thrown by both sides. Malad, if your lordship then takes it up just after the vacation, if it's possible to your lordship. It's my request, Malad. It's my folly. I'm not.
Provided you give, you undertakes before this court that you will appear. On
I will appear. But my undertaking, I will appear, Malad. If your lordship records my undertaking, you record them. Not a problem at all. I will.
Be taken up. I wanted to show 2-3 judgments and one fact only. That I'll be.
And if Mr. Bandyopadhyay can give the judgments, that will be very nice. Then I can also assist the court on that day itself.
Now the query of the court is,
Malad.
suppose an order is passed by a bench, which can't be implemented. In
Or
accordance
without
with law.
jurisdiction also.
Cannot be implemented in accordance with law.
Whether contempt lie or not. But I will assist your lordship. I will assist your lordship on that.
So
I
on
think-
that issue, I'll be showing 2 judgments. In fact, their recalling application has been dismissed. An appeal taken from the liberty granted that Malad, do you want?
But even then, Mr. Bandyopadhyay,
The order
The
stands.
situation-
Malad, the Supreme
order
Court has said,
stands
Supreme Court has
and
said,
the situation remains unaltered.
the Supreme Court has said in uncertain terms, Malad, one is 5 judges bench followed by 3 judges bench, that a wrong order, unless it is set aside by the Malad higher bench, Malad, it will be binding on the party.
Yes, tell me the citation.
Malad, I'll first go 63. Malad,
63,
AIR 66 SC 1061
AIR 66,
SC
Yes, he was this one.
1061 paragraph 15 followed in 2007 7 SCC
2007,
7 SCC 689 paragraph.
689,
89 my lord.
paragraph.
Well, paragraph I'm just giving. Most probably paragraph 31, my lord. I'm just again checking it up.
Very well. Paragraph 31, but that has to be subject to.
Subject to my lord.
Policy. It's contrary to law. It is both in the external, it is interpretive. একটা কপি দেবে দাদা? এটা তো দাদা রুল আছে। একটা কপি আছে?
মাছ দিচ্ছি দাদা।
Mr. Bandyopadhyay, there are judgments against you also by the division bench of our High Court as well as it is by Justice Sinha, headed by Justice Sinha.
We have got
Sri Shubhir Banerjee and others versus Sunil Kumar Dasgupta. Calcutta Law Times, 1998, 3, High Court, page 98. Paragraph 11, 17, 18, 19.
3.
Calcutta Law Times, 1998, volume 3, High Court, page 98. Where Mohammad Iqbal Khande was considered by the Supreme Court judgment.
2007, I'll be giving the page.
In paragraph 16 of
it is
Mohammad Iqbal Khande, it says, from the above, it appears that the appellant was expressing his genuine difficulty with regard to the implementation of the order dated 21st September 1992. In such a situation, the insistence of the courts on implementation may not square with realities of the situations and the practicability of implementation of the court's direction. In our considered view, hooking a party to contempt proceedings and enforcing obedience to such orders hardly lends credence to judicial process and authority, more so in a particular facts and circumstances of the case. The court must always be zealous in preserving its authority and dignity, but at the same time, it will be inadvisable to require compliance of an order impossible of compliance at the
Impossibility of
instance of the
performance.
person proceeding with the country.
Well, there is an impossibility of performance, nothing to do with this type of order. It's a grant of pension.
Now, today, the query of the court that the law does not prescribe this.
My lord, I had shown on the last occasion that if it is interpreted, my lord, as I shown, my lord, it will be that
Not by way of inferential reasoning. No, Mr. Bandyopadhyay, it's a payment of, it's a question of payment of terminal benefits. It must be backed by specific statutory provisions.
My lord, I had
By process of inferential reasoning, you cannot conclude that that the petitioner's service was a pensionable service.
Malad, that was the,
Precedent also.
that was the, Malad, now after that, Malad, they have now,
Since you are, Mr. Rai, since you will appear, come prepared.
I will.
Malad, 2007, you'll also kindly note the.
Yes, I have noted.
No, no,
Yes,
not
yes.
31, paragraph 15 and 25.
Yes.
And I'll also come with other judgments, Malad. Because this is not a case where it is not impossibility of performance case. Those
If
judgments,
there is no statutory provisions, how this court can direct the pay pension?
Malad, I had shown Malad, then
Suppose,
Malad, just your
please,
Lordship is
please,
supposing
please
the
answer the query
situation.
of the court. A person is working in a kindergarten school. He comes before this court, pay me pension. Whether court can direct?
Malad, this was hard, not expertise. This was hard in
Might
presence
be,
in presence
might
of-
be. But if this his service is not pensionable, what is the scope of granting relief?
I had shown on the other.
Anybody and everybody come before this court, pay me pension, and court will grant pension.
Mr. Bandhavadhyay is proposing that there is a slight difference. If it's contrary to law, then even if it's a wrong order, res judicata will apply. But it will not be executed by a court because it will be a wrong implementation of law. What Mr. Bandhavadhyay is, it is there. There's a contractual dispute. Wrong order. Then, it becomes because it's between both the parties. But here it will have a precedential value.
Not only this, the right of the petitioner to get pension must be backed by the statutory provision.
That is what
There is such provision.
Malad, once it has been adjudicated upon, by a competent court of a coordinate bench.
Well, I'll consider.
That I will not see. Because otherwise the contempt court will be going in every case behind the order. But which is also not permissible.
That is permissible. I will show that.
That is permissible in
that is
certain cases.
That much I will show.
In an
So if I
exceptional-
direct that bring moon for me,
No, no,
if court directs, that is not an implementable order.
exceptional circumstance, Malad, on the last.
Affidavit of service filed on behalf of the applicant is taken on record. Next paragraph, Mr. Rai, learned government pleader, appears on behalf of the alleged contemner and prays for accommodation to come better prepared. Next paragraph, list the contempt application under the same heading on.
It will be Friday.
14 June 2025.
Yes.
Judgment recorded.
We'll come back. I'll also consider the judgments which you have referred to.
Yes, Malad, I'll again show the rules. On the last occasion I had shown.
No, my mind is open. There is no, but I'm expressing what is passing through my mind.
Malad, that is expected.
For me also, I would have objected, but for the presidential value.
And you are appealing for the school authority. You are required to obtain instruction whether
There's
any
no problem,
government
Malad,
circular or anything is there, which makes an employee of the school or a teaching and non-teaching staff of the school entitled to receive pension.
Private school.
Well, after 2006, school has also denounced the DA. And that is why there cannot be any instance, Malad, after 2000.
File a short affidavit. Add a line that देखिए एक बार फिर ये रिकॉर्ड तो देखिए added alleged contemner is represented by learned advocate. Stop. The added alleged contemner is directed to file a short affidavit explaining whether the service of the petitioner is pensionable or not.
Should I?
I'm sorry.
Yes. Yes. It's not required. You have deposited the cost.
Lordship, I have deposited.
So now the addition of party be restored. Application for addition of party.
Fine.
This was dismissed for default.
This was dismissed for default.
Can 2 of 29.
Can 5.
No. Can 5 is the recording
Restoration application.
Dismissed for default is can
Is
2
can
of 2019.
Lordship. The old number is 9597 of 2019.
9597 of 2019.
Lordship.
Issue.
Condonation of delay.
Pursuant to the previous order dated 10th May 2024, the applicant has deposited the cost, and in support of the same, documents are produced before this court and same are taken on record. Stop. Next paragraph. Today, application for recall of the order dated 4th November 2019 whereby the application being IA number can 2 of 2019 within bracket old number 9597 of 2019 close bracket was dismissed for default, comma, is taken up for consideration. What is this can 4 and can 3 2020?
That is the restoration of the writ petition. Initially, the application for addition of party was dismissed for
These
default.
were allowed.
That was that have
Can
annexed.
3 and can 4 both were allowed.
Both were allowed. That order is at page 10
Page 10
of this application, man. Can 5. First, the application for addition of party was dismissed for default. Thereafter, writ petition.
Now this order has been 22nd March 2024 order has been restored.
That has been restored.
Has been recalled.
Recalled. And writ petition has been restored.
Addition of party কি আমাকে দিয়েছো? না এগুলো দিয়ে
Next paragraph. Having perused the explanation offered in the application being can 5 of 2024 seeking recall of the order dated 4th November 2019. This court finds sufficiency of cause. Stop. Next paragraph. Accordingly, the order dated 4th November 2019 stands recalled, and the application being can 5 of 2024 is restored to its original file and number. Next paragraph, the application being can 5 of 2024 stands disposed of. Well,
May I solve the application upon the parties and may not come back any day after vacation.
hearing of the writ petition.
Hearing of this application for addition of party. Because unless and until the application
Let
is
the application for addition of party being it is can 2 of 2019.
can 2 of 2019.
Can 2 of 2019 within bracket old number can 9597 of 2019 be listed under the heading application in the monthly combined list of June 2024. Stop. The learned advocate representing the applicant is directed to serve notice upon the non-appearing respondents enclosing copy of this order by 7 days from date and file affidavit of service on the agenda.
I'm grateful.
Next.
Item number 10.
The pursuant to the last occasion, was directed to file the service by serving notice once again. This is a restoration application allowing condonation delay of 2 months.
Just a minute. Issue. Both the applications, one being 5874 of 2018, one being can 2 of 2018 within bracket old number can 5874 of 2018 close bracket, seeking condonation of delay in presenting the recalling application. Another being can 1 of 2018 old number can 5873 আগেরটা 5873 বললাম তাই না? না 5873
Condonation 5873.
5873 can 1 বুঝলে 5873 can 1 আগেরটা কি বললাম? হ্যাঁ can না প্রথম অর্ডারটা পুরো সেন্টেন্সটা পড়ো না can 1 of 2018 can 1 of 2018 old number can 5873 of 2018 close bracket in presenting the recalling application. Yes, another being can 2 of 2018 within bracket old number can 5874 of 2018 for recall of the order dated 5th June 2018 are taken up for consideration in presence of the learned advocates representing the applicants and state respondents. State respondents. Stop. Affidavit of service filed on behalf of the applicants applicants are taken on record. Next paragraph. On perusal of the explanation offered in the application seeking condonation of delay, this court finds that sufficient cause has been explained in presenting the recalling application, and accordingly the delay occurred in presenting the delay occurred stands condoned. The application being can 1 of 2018 stands disposed of. Next paragraph. On perusal of the explanation offered in the application seeking recall of the order dated 5th June 2018, this court expresses sufficiency of cause, or this court finds sufficiency of cause. Stop. Accordingly, the application being can 2 of 2018 is allowed and disposed of. The order dated 5th June 2018 stands recalled. The writ petition is restored to its original file and number.
Well, this since the matter, my lord, the earlier order direction for production of the records report, lord, let the matter be fixed on NDD after the vacation. My lord.
What is the matter?
Third May
is under which subhead?
Well,
Group 5 is a panchayat matter.
Relating to the panchayat affairs.
Panchayat. It is at a hearing stage or?
It is the hearing stage.
Hearing stage. There was a direction for affidavits.
No, my lord, it is a motion stage, my lord. It is motion stage.
But 3rd May, your order was there.
The direction would for report, my lord, but it is a contractual appointment by the contractor. And the government has nothing to say in this.
Argument.
Next paragraph. List the writ petition. List the connected writ petition under the heading motion under the heading Group 5 Panchayat motion for disposal. Group 5 Panchayat motion for disposal in the monthly combined list of July 2024. Stop. The learned advocate representing the petitioners is directed to serve notice upon the non-appearing respondents, enclosing copy of this order by 1 week after ensuing vacation, and file affidavit of service on the adjourned. Next. তাহলে ওইটা করে দাও যে that can so and so be treated as on days list. Can 5 of 2024 করা আছে। তো কেউ নেই। তো মানে can 2 of 2019 নিচে একটা করে দাও can 2 of 2019 be treated as on days list. আমরা কত respondent number 1.
Item number 7 from monthly list of appellate side.
I did appear on behalf of the finance.
My lord, I appear for the petition, my lord.
My lord,
My lord, last.
that order was passed on 16 September 2022
and appeal was filed on 19th September 2023, and appeal did be received on with all objections on 25th September 2023. But it has not been could not be mentioned that before the group 9 matter, code number 1. It has been informed that no date has been fixed. Wait for some time. Section 5 Section 5
holding now, admit you are in section 5 or
The order dated 16th September 2022.
Yes.
What you are doing for such a long time?
No, but
there is a change.
Now when they are proceeding
there
with
is
the
a change of
contempt you are
panels.
mentioning.
That's why the appeal was filed on.
Now when they are proceeding with the contempt you are mentioning, Mr. Mukherjee.
Malat?
When they are proceeding with the contempt you are now mentioning before the division bench.
No, division bench it was mentioned earlier. Then wait for some time. Then again it was mentioned before the contempt matter is pending. But that will take up. Wait for some time. And
kindly sees one order.
With the, we cannot blame anybody because other matters are taken up. Public interest litigations and original side matters.
What is the number of the contempt? 1881 or 1868? Hey, number of the mat.
Mat number 3.
One is filing number, another is registration number.
1868, no?
1868.
1868.
Then it appears from the status report of that appeal that the first hearing took place on 22nd September 2023. First hearing date was 22nd September 2023.
Yeah. Then
next hearing date.
Next hearing date.
What happened on 22nd September 2023?
No, in the meantime, what the earlier advocate general was appearing.
In the meantime, the learned Mr. Mukherjee, learned advocate was appearing in this matter. Then change of learned advocate.
Wait for some time.
My lord, I have already waited. My lord, kindly sees the order.
Since they have preferred an appeal, let a chance be given.
My lord, there is no stay, my lord. Lordship will kindly record my submission, my lord, kindly. Because I have been waiting, my lord, from...
The contempt application is taken up for consideration. When Mr. Mukherjee, Mr. Tapan Kumar Mukherjee, learned additional government leader, submits that one intra-court appeal being MAT 1868 of 2023 has been preferred against the order dated 16 September 2022 passed by a coordinate bench on the connected writ petition along with stay application. Stop. Next paragraph. In view of the pendency of the appeal and stay application, hearing of this contempt application stands adjourned for 8 weeks. Stop. List the matter contempt application under the same heading. In the monthly combined list of August 2024.
Well, there was a cost imposed by an order of 23rd February 2024. Let them first show their conduct that they have complied with this order, at least in the contempt petition.
Payment of cost contempt is not.
No, in the contempt petition, learned judge was since from October 2023. They have been praying for adjournments, only citing the pendency of the appeal. Learned judge after giving them 4 chances, imposed cost.
Well, let them take a chance. That will not be the proper thing. Let them take a chance and.
May I only pray, kindly.
Modern food says today, if the contempt application is order is implemented, nothing remains in the appeal will be infructuous. That will not be the proper.
In the event, it is not taken up, then Lordship permits me to move my contempt.
That's why I have directed that matter. I have not directed the matter to go out of list sine die.
Fix the matter.
Yes. Careful. Huh? ওই দেখবে একটা পেপারটা আছে দেখি উপরে ওটা যে স্ট্যাটাস রিপোর্টটা দিল তাতেই তো লেখা আছে দেখি তো বলি এই দাও 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 তাতে দাও
আমি একটা
ভুল করবে আমাকে আবার কারেকশন করতে হবে দেখি শুধুই পেপারটা 1868 of 2023 Come back, come back. After
I was only praying if Lordship considers recording my submission that there is no stay, so the contempt could be proceeded with. Only if Lordship kindly, some problem at our end, my lord, otherwise, my lord.
What can be done? The appeal has been preferred, chance should be given. Next matter.
Item number 9.
My lord, I am for the applicant. My lord, for violation of interim order passed by His Lordship the Honorable Justice Soumitra Pal, who was then dated 11 March 2014. This contempt application has been filed, my lord. My lord, kindly see page 47. the
First
interim-
time, first time contempt.
First-
Where is the order?
Page 47, my lord.
Page 47.
Yes, sir.
Whether this order was, this interim order was.
Yes, my lord. Yes, the interim order was several location was extended, and lastly, by order dated, my lord, 20th 11/2014, passed by His Lordship the Honorable Justice Aniruddha Bose, was then, my lord, page 53. That shall stand extend until further order, my lord.
Writ petition is pending.
Pending, my lord. And this writ petition was come before His Lordship, the Honorable Justice Aniruddha Roy, on 7th November 2022, my lord. And order page 69.
Yes.
Page 69, my lord, page 69. The opportunity was given for further hearing, but thereafter His Lordship determination was changed and the matter was not heard out, my lord. And in the meantime, they have violation the order, appointing another person.
No, when Emad dealer was appointed,
And my lord, after communication disorder,
when you have communicated,
on my lord, 10th November 2022, page my lord 71.
why the order dated 11 March 2024 was communicated in 2022?
No, my lord. After the order of His Lordship the Honorable Justice Aniruddha Roy,
But
passed
that is
in
why or simply-
passed in 7th November 2022. This order was communicated, my lord. But the initial order was communicated from the beginning. And my lord,
that is in connection with the writ petition.
writ petition interim order when was passed, my lord. When interim order was passed, that was communicated. They appeared. Civil location interim order was extended. Even when the interim order was for until further order, they also appeared.
No, Justice Rai did not pass any fresh interim.
Any order should just
It was
inform the
already
order.
there. Now the interim order was extended till disposal of this.
That order was communicated.
Until
my lord.
further order.
That order was
on 20th November 2014.
And that was communicated.
That was your
Then when the act of contempt took
in
place?
2023. They have violated the order in 2023, my lord.
On which date?
My lord, no particular date, but they have, I came to know that they are appointed dealer and they are already operating and distributing the ration, my lord.
Issue. Petitioner, the learned advocate representing the applicant alleges violation of the order dated 20th November 2014, passed by a coordinate bench on the connected writ petition. Stop. Next paragraph. The learned advocate for the applicant is directed to serve notice upon the alleged contemners, enclosing copy of this order and the copy of the contempt application by 2 weeks from date and or by 1 week after ensuing vacation, and file by 1 week after ensuing vacation and file affidavit of service on the adjourned date. Next paragraph lists the contempt application under the heading new contempt in the monthly combined list of July 2024. Stop. Next paragraph. However, pendency of this contempt proceeding shall not preclude the alleged contemners to comply with the order passed by the coordinate bench on 20th November 2014. Next.
Okay.
Item number 10, blood. I'm appealing for the petitioner, blood. Your Lordship, kindly see the order dated 10 January 2023, blood, passed by the Honorable Justice Labita Banerjee, blood, which is annexure P1, page 19. Blood, against the order, blood, they preferred an appeal and also stay applications, blood. That was, appeal was heard and that was dismissed, blood. Your Lordship, in operative portion is, Your Lordship, kindly see, blood, page 21, fourth paragraph. In the light of the, may I read, blood?
Just a minute.
Matter is relating to area family pension.
This order dated 10 January 2023.
2023, blood.
কমিউনিকেশন করেছিলাম তো বলছে পেয়ে গেছে নাকি
তাহলে কমপ্লেন্স রিপোর্ট তো দিয়ে দেবেন তো
পরের দিন দিয়ে দেবো
Yes. Area pension.
Now, after the initially there was a stay in the appeal, but after the appeal,
There is no
having
stay. There is no stay. Initially, there is no stay on the matter.
Now the appeal has been dismissed.
now the appeal dismissed, appeal fails. Now, my lord, my instruction, my lord, another maximum 3 weeks time, my lord, papers already proceeded with. Now, my lord, the requisition sent to the state government because the North Bengal State
When the
Transport.
appeal was dismissed?
মানে appeal dismissed, my lord,
5th February.
আমি তো কিছু তো বলতে পারি নাকি না? মানে 5th February 2024. Thereafter it
What
was,
you are doing for such a long time?
my lord, my instruction is that my lord, the
When the contempt application is being heard, you will take the plea that
yes,
further
yes,
time will be
yes.
required.
No, my lord, may I tell, my lord, just my lord, this is my lord, over telephone, my lord, the communication is that my lord, senior law officers,
Let the senior
seniors.
officer remain present before this court.
No, my lord, but now, my lord, may I tell, now, my lord,
Preferred an
it has
appeal,
been,
you failed in the appeal.
yes, yes, now it has
Therefore,
been
why by
proceeded
this
with.
time the order should have been complied with?
No, my lord, yes, that's my lord. I also asked for that, my lord. The answer was that the senior law officer, my lord, who was responsible to, my lord, the place the file, but his wife, because of the cancer patient, my lord, all off and on, my lord, he took, my lord, a leave.
Think about
That
the
is why,
person who has
that
retired.
is why the problem
Think
created.
about the person who has retired long back. He may not be a cancer patient.
No, this is this is
The
for, my lord,
senior
the
citizen
area.
and the area.
No, this is
for the period from 6th November 2011 to 3rd October
the,
2017.
my lord, no, this is not for the, this is a area family pension. The son said that my mother used to receive the pension, so I am also entitled. It was allowed. The moment he prayed for that, it was allowed. But the rest of the period was not allowed because contention was that you applied for family pension after 4 or 5 years. So that is why. Then after the writ petition file, he succeeded in the writ petition. Appeal now fails. Well, it has to be released.
The petitioner is the wife of the
No,
Son of the deceased employee.
Son
of the deceased employee.
Son of the deceased. Originally, the deceased, yes, son of the deceased employee.
So why this area accrued?
But area accrued, may I tell?
Because of revision.
Area accrued, may I tell? But the original employee died sometimes in 2009 or 2010. Then his wife, two wives, both claimed for family pension. Now, after all, one of the wife succeeded and family pension used to release. Then she died in 2011 sometimes. After that, nobody claimed for family pension. In 2017, the present petitioner, writ petitioner, claims that he is the son, so he pays for that area family pension.
Which was payable to the
Payable to him.
the
Yes.
deceased employee.
So now I am entitled to.
Yes.
So now yes. Now after all he succeeded that. Now my lordship kindly give some time, because people are already forwarded. I am told that.
Contempt in the contempt application, applicant alleges violation of the order dated 10 January 2023. Stop. It is also submitted by the learned advocate representing the alleged contemner that the appeal that the intra-court appeal preferred against the order dated 10 January 2023 was dismissed by the Honorable Division Bench. By order dated?
By order dated 5th February 2024.
Where is the order?
Well, yes.
By order dated. February 2024. Stop. Next paragraph. Mr. Sen, learned additional government pleader, prays for time to comply with the order, comply with the directions as contained in the order dated 10 January 2023. Stop. List the contempt application. Next paragraph. List the contempt application under the heading new contempt, quote unquote new contempt, on 14 June 2024 in order to enable the alleged contemner to release the in order to enable the alleged contemner to comply with the order dated 10 January 2023 and to file affidavit of compliance.
Get.
Next paragraph. The order passed by the Honorable Division Bench dated 5th February 2024 is taken on record.
My lord, get.
Next.
Item number 11.
11, I am for the opposite party alleged contempt. Beseeching your lordship to kindly look into your lordship's my lord order dated 8th of March.
Just a minute. Issue. It is in connection with criminal revision.
Criminal.
At the time of call, no one appears for the applicant and no accommodation is paid for. However, opposite party is represented by learned advocate. Stop. Next paragraph. Same situation prevailed on 19th April 2024. Stop. It appears applicant has lost interest in the fate of this contempt application. Stop. Accordingly, the contempt, next paragraph. Accordingly, the contempt application stands dismissed. However, there shall be no orders to cost. Accordingly, contempt application stands dismissed. Contempt proceedings stop. Contempt proceedings stands dropped. However, there shall be no orders to cost. Urgent Xerox certificate copy. Next.
Item number 12.
I'm appearing on behalf of the petitioner, Your Lordship. An order was passed on 12th of December 2022, which is at page number 19 of the contempt application, Your Lordship, wherein the Lordship directed the respondent number 2, that divisional forest officer, to consider my representation and pass a reason order. Thereafter, a hearing notice was issued and a hearing was conducted on 9/2/2023, but till date, no reason order has been passed. On the last occasion, when my Lord Justice Bhattacharya taken up, there is an order for service was passed, and this is my affidavit of service, Your Lordship.
You are complaining of violation of the order dated 12 December 2022.
12 December 20, which is at page number 19, Your Lordship.
Yes, just a minute.
An operative portion is at page 20.
Hearing was conducted, but
Hearing,
no order.
no reasoned order been passed till date.
You have served notice indicating that matter is to be heard by this court or by the by the coordinate bench.
Yes, Your Lordship.
Serve another notice and come back.
Yes, Your Lordship.
The learned advocate representing the alleged representing the applicant, learned advocate representing the applicant alleges violation of the order dated 12 December 2022 passed by a coordinate bench on the connected writ petitioner. Stop. Today, no one appears for the alleged contemner and no accommodation is paid for. In spite of service of notice upon the alleged contemner, stop. Affidavit of service filed on behalf of the in spite of service of notice upon the alleged contemner. Stop. Affidavit of service filed on behalf of the applicant is taken on record. Next paragraph, the learned advocate for the applicant is directed to serve another notice upon the alleged contemner. Have you served a copy of the contempt application?
Yes.
Upon the alleged contemner, enclosing copy of the order passed by this court today by 1 week after or by 10 days or by 7 days from date, and file affidavit of service on the adjourned date. Next paragraph, list the contempt application under the heading new contempt on 21st June 2020.
Yes, Your Lordship.
Next.
Grateful.
Item number 13.
Is nobody is appearing? No. At the time of call, no one appears for the applicants and no accommodation is paid for. Next paragraph. List the contempt application under the heading New Contempt on 14th June 2024. Stop. Next paragraph. However, it is made clear if on the adjourned date applicants go unrepresented, consequential order shall be passed. Next.
Item number 14.
May proceed. Page first time, page 24 reveals the order in question, which one put on test before the division as upon the order of the single judge.
Judgment dated 18th April 2023. Oh, judgment dated
18th April 24. Page 24. Operative lordship will find from
paragraph.
Operative lordship will find from page 32. In fact, 30 will reveal the directions.
Issue.
This was confirmed
by the division
bench. Lordship
the
may
learned advocate representing the
may have a
applicant alleges violation of the order, violation of the judgment and order dated 18th April 2023, passed by a coordinate bench on the connective writ petition. passed by a coordinate bench of the connected writ petition, it is also submitted that an intra-court appeal being MAT 1675 of 2023 was preferred against the said judgment dated 18th April 2023, and the same was dismissed.
Dismissed, straight away dismissed. Lordship will find from the page 6. We therefore find no merit.
And the same was dismissed.
Yes.
VDA ordered it, কি বললাম sentence টা? Video ordered it 8 April 2024 of the Honorable 8 April 2024 of the Honorable Division Bench. 8 April 2024. Stop. Next paragraph. The learned advocate representing the applicant is directed to serve notice upon the.
And as per this order is concerned, we already communicated. Lordship can have a look of the same. This order was also stood communicated.
Upon the alleged contemner. Serve notice upon the alleged contemner, enclosing copy of the have a copy of this contempt application and the order of this court by 7 days from date, and file affidavit of compliance on the next date. Next paragraph. And file affidavit of service on the next date. Next paragraph lists the contempt application under the heading new contempt on 21st June
21st, yes. Great. The Lordship has already posted on.
You have already communicated the.
Well, I've already communicated the order of the dismissal. As per the. I've already.
I thought that you have supplied the copy of the contempt.
I've already communicated the order of the dismissal in order to activate the order.
Call the next matter.
Great.
Item number 15.
Mr. Partha was appearing for the petitioner against a single bench order, and appeal was preferred by the respondent, which is disposed of. May I hand over the order?
You are for the applicant.
I'm for the applicant.
Now, appeal was disposed of, modifying the order passed by the coordinate bench.
It has been slightly
So
modified.
therefore, the contempt does not lie.
No, Your Lordship.
Is not maintainable.
No.
The learned advocate representing the applicant submits that the order passed by the coordinate bench on the connected writ petition dated 4th May 2023 was appealed against on presenting an intra-court appeal being MAT 1385 of 2023. Stop. According to the applicant, the said appeal was disposed of by the Honorable Division Bench, video order dated 28 February 2024, modifying the order passed by the coordinate bench on 14th May 2023. Next paragraph. In view of such submission made on behalf of the applicant and the order passed by the coordinate and the order passed by the Honorable Division Bench on 28 February 2024, it appears that the order and judgment dated 4th May 2023 passed by the coordinate bench merges with the order passed by the Honorable Division Bench dated 28 February 2024. Stop. Next paragraph. Accordingly, the contempt accordingly contempt application stands disposed of and contempt proceeding stands dropped. Stop. Urgent xerox certificate. Done.
This is an application for restoration. On the last occasion, your lordships have heard in this matter. My learned friend was not there. Your lordship, this is the dismiss has been caused due to the death of my father.
Yes.
Lordship, on that occasion, I could not be able to present before my lord, because my father was died on 7th of November, and the rituals were there, so I could not able to attend the hearing.
Service was required as well. It
Lordship,
was submitted.
on the last occasion, affidavit of service, my
The restoration application.
lordship, restoration application and delay was there, your lordships. On my personal ground, it was there. My learned senior friend was not there on the last occasion. He was only appearing at the time of dismissal. On the last occasion, your lordship, so far as the private respondents are concerned, I have.
Why two applications?
For delay is there, your lordship.
About 1 year.
Lordship, I could not able to. Lordship, I do not know that the matter has come up. That's why I could not able to. Subsequently, when I found that they are again started construction illegally, then I have searched out, and at that point of time only I have come out, found that this matter has been
You are not
appeared.
vigilant. That's why you did not know that your matter was dismissed for default.
Lordship, on 22nd.
When you after the dismissal, when you found that new construction was being made, then you woke up from slumber and tried to ascertain what is the reason for making such construction.
No, your lordship.
In the meantime, 365 days gone.
290.
Yes.
298 days in there, lordship.
What is the explanation given in the Section 5 application? Let
Section
me see.
5, your lordship.
You are enjoying an interim order?
No. Your lordship, it is in the motion, at the motion stage, your lordship, with regard to
What is
the
the
illegal
explanation?
construction.
What is
your
the
lordship.
explanation in the condonation of delay application?
Lordship, page number 5, your lordship, para 5, that for a long time the respondent number 5 stopped the illegal construction, as it is, we are on the impression that respondent will not construct any building. And subsequently, on 10th of October, your petitioner found that respondent number 5 has again started the construction. Your
Yes,
lordship.
because the petition was dismissed. He
Yes,
did the right thing.
And immediately your
Petition was dismissed on 22nd November 2022.
Lordship.
And on 10th of October 2023, you found that
They have started construction. Lordship.
That is the explanation.
Lordship, that's why I could not able to. That is there. What is there, your lordship, I cannot.
That is the explanation. When private respondent was served?
Lordship, private respondent was served earlier, your lordship. On the earlier occasion, I have filed the affidavit of service. On that day, only my learned senior friend was appearing for the time of dismissal, your lordship. That's why your lordship's pleasure was to intimate my learned senior friend.
হ্যাঁ সেটা আমি তো ঠিকই আছি বলতো আমি তো কোনো বিবাদ নেই।
You should pay cost of rupees 5,000 rupees.
It will be paid by my pocket, Your Lordship. That's a
That I do not know.
Your Lordship,
I would
I only
because
can-
I'm not satisfied with the explanation.
Lordship, I'm leaving it up to Your Lordship.
Two applications, one being Can 1 of 2023 seeking condonation of delay in presenting recalling application. Another being Can 2 of 2023 seeking recall of the order dated 2nd November 2022 are taken up for consideration in presence of the learned advocate representing the state respondents. Stop. Next paragraph, affidavit of service filed on behalf of the applicant is taken on record. On perusal of the restoration, on perusal of the application seeking condonation of delay and hearing the learned advocate representing the applicant, it transpires that the connected writ petition was dismissed for default on 22nd November 2022 and the recalling application was filed on 17th October 2023. There is approximately delay of 1 year. The applicant has made an attempt to explain the delay, but on perusal of the explanation, the court is not satisfied. Stop. Next paragraph. However, for the ends of justice, the application seeking condonation of delay is allowed. Thereby, seeking condonation of delay is allowed subject to payment of cost of rupees 5,000 to be deposited with the High Court Legal Services Committee by 7 days from date. Stop. Next paragraph. However, it is made clear in the event applicant fails to deposit the cost within the aforesaid time, the order passed today stands. The order passed today shall stand recalled without any reference to this court. Next paragraph lists the recalling application being Can 2 of 2023 on June 2024 under the heading application in the supplementary list.
The time may be extended? Time for depositing can be extended?
ওটা ওই যে by 7 days করলে যেটা করা হলো ওটাকে করে দাও by 7 days, but that will be the last date before the vacation.
I know that. Can it be within 2 days from the reopening? Can it be? Subject to your lordships.
ওটা তো করে দাও ওই by 7 days টা কেটে দাও by 11th June 2024. Your application for recalling will be in the supplementary list subject to
Lordship.
payment of cost. It will be considered. Yes, next.
Item number 66.
Oh. Issue. Let the matter appear under the same heading in the monthly combined list of June 2024 in terms of the order dated 3rd May 2024. Next.
Item number 67.
My lord, I am for the petitioner, my lord. My lord, affidavit service for restoration application along with my lord combined petition for condonation of delays.
How many days delay?
My lord, 176 days, my lord.
Only?
My lord, only.
Only
Because
176 days.
My lord, advocate on record, my lord, did not come court due to illness
under what provision you have filed a combined application? I could understand if it is a substitution application.
No, joint combined prayer, my lord. My lord,
Why?
recalling
Why?
Recalling the
It
order.
is not a case of 2 or 3 days delay. Considerable delay has taken place.
My lord,
Why
kindly consider, my lord.
Where is the explanation of the delay?
So, my lord,
explanation.
I have pleaded, my lord, in paragraph number
25th January 2023.
My lord, kindly see paragraph number 8 that I have contacted the petitioner several times, but the number that time, the mobile number has not reached, my lord, and last on 18 July, my lord, petitioner came to the chamber and then filed the restoration application, my lord, as soon thereafter, my lord.
There is the explanation. Where is the letter sent by you to?
My lord.
Where is the letter you have sent to your client? Applicant?
No, by phone, my lord.
Who will believe it?
My lord, 2021, that matter was affirmed, but that
File
time,
application. Giving appropriate, explaining the delay.
my lord, section 5 application.
Yes.
Kindly give
Issue.
liberty, my lord.
At the time of hearing the application being Can 1 of 2023, seeking recall of the order dated 25th January 2023, the learned advocate representing the applicant has prayed for leave to file an application seeking condonation of delay in presenting recalling application. Stop. Next paragraph. List the matter in the combined monthly list of July 2024 under the heading application in order to enable the learned advocate representing the applicant to take necessary steps. File an application.
Yes, my lord.
Next.
Item number 68.
So group 2 matter?
No, the municipality. Within time.
I thought it's a group 2 matter. Wrongly it has come before me.
Entirely my
If it
fault.
is group 6, how this will come before me?
Municipality.
Group 6 is not municipality, Mr.
No,
Bari.
service matter relating to municipality.
This has been classified as group 6. Writ petition has been classified as group 6. I have no determination to take up group 6 matter.
No, because the Calcutta Municipal Corporation, you'll also kindly see the respondents. Calcutta
Maybe, but I have to see the presentation form. If you find that it is a group 5 matter, I am granting you leave to amend the cost title and presentation form and come back.
presentation form here and now I am correcting my lord. It is my fault, your lordship. That's why I am appearing within 14 days. It was filed. Your lordship kindly have a look, paragraph 3. Otherwise,
On perusal of the record, it appears that the connected writ petition was classified as group 6 matter. Stop. Next paragraph, the application is a dismissed matter, dismissed for default matter. I cannot grant to any leave.
no, initial
Let the application be released from the list due to want of determination and be placed before the appropriate bench. Next. If the writ petition would have been pending, then in that case, I could have directed the matter to appear on a subsequent date, granting you leave to amend the presentation form and the pro forma. But in a disposed of writ petition, how I can grant?
now let us check up, my lord, whether the original presentation form is group 6 or
Yes, original writ petition, it is group 6. Check it up. Just a minute. Because in the presentation form of the application, you are not required to classify the writ application. Dako, next matter.
Item number 69.
I am for the petitioner. It is a restoration application. This is for default on 24 April. Are filed within the time.
Restoration application?
Within the time. Within time. Affidavit of service, my lord.
Where is the affidavit of service?
Right. Group 5 municipality hearing matter. Opposition reply all are completed.
Yeah. 6 June. No, that is not within time.
My lord.
Order was passed on 24th April 2023 and you have filed the restoration application on 6th June 2023.
It is my lord.
April, May, June, it is beyond time.
Section 5 application.
30 days. So therefore from 24th April, 30 days ended
lord,
on 23rd May 2023.
Pardon me, my lord.
Why are you saying that it is within time?
No, my lord, pardon me.
It is your application, you do not know. I have to find out whether it is within time or not.
My lord,
and if I fail in finding it, I would have passed an order.
no.
Why you are making such wrong submission before this court?
It is not indicated in AFAM. That is so I am date of AFAM, it is not indicated. So I am.
Yes, it is affirmed. It was affirmed on 15th May.
That
was within time. Affirmation was within time, but the filing was on 6th May, 6th June 2023.
Pardon me.
Issue. Affidavit of service filed on behalf of the applicant in connection with the recalling application is taken on record. However, no one appears for the respondents today. Next paragraph. The learned advocate representing the applicant has prayed for accommodation to file application seeking condonation of delay in presenting recalling application since the recalling application was filed beyond the statutory period of limitation. Stop. Next paragraph lists the recalling application under the heading. List the matter. List the matter under the heading application on 21st June 2024 in order to enable the learned advocate for the applicant to take necessary steps. Next.
Item number 70.
You are for the state. Issue. At the time of call, no one appears for the applicant and no accommodation is paid for. Stop. However, state respondents are represented by learned advocate. Next paragraph, on perusal of the application being can 1 of 2023, it appears that the applicant has prayed for enlistment of the matter for early hearing. Stop. Since the connected writ petition pertains to group 5 of the classification list of different types of writ proceedings, let হবে না কেটে দাও ডিসপোজ হয়ে গেছে writ petition. এই এনলিস্টমেন্টটা যেটা সেন্টেন্সটা একবার বলো তো। Stop. However, the writ petition being WPA 20921 of 2021 was disposed of video order dated 20th September 2022 passed by a coordinate bench. Stop. In view of disposal of the writ petition, the present application is not maintainable. Stop. Accordingly, the application being can 1 of 2023 stands dismissed. However, there shall be no orders to cost or then there is a copy. Next. Fix করতে যাচ্ছিলাম ম্যাটারটা তার মধ্যে ডিসপোজড হয়ে গেছে।
Item number 71.
July 2022. শুভেন্দু এসো। এটা না শুধু ক্যান ওয়ান এর উপরই করবে, এটা ক্যান টু আছে তার কোনো ইয়ে নেই। At the time of call, no one appears for the applicants, and no accommodation is paid for. Stop. Previously, on 22nd March 2024, hearing of the application being can one of 2023. Now, hearing of the application, hearing of the application was adjourned on the prayer made on behalf of the applicant. Applicants. Stop. Next paragraph. It appears that the applicants have lost interest in the fate of the application. Stop. Accordingly, the application being can 2 of 20 being can 1 of 2023 can 1 of 2023 is dismissed. উপরে দেখো তো can 1ই বললাম তো না can 2? Can 1 is dismissed. So, urgent xerox certificate code. Next.
Item number 72.
Lord, in item 72, I've just been informed that Mr. Dilip Kumar Samanto is appearing. He is unwell, and I have been requested by his clerk to seek for an accommodation today, Your Lordship.
এই শোনো 72 তে দুটো ক্যান একই নাম্বারে দুবার করে প্রিন্ট করেছো কেন? ক্যান 3 of 2023, ক্যান 3 of 2023. Issue. At the time of call, accommodation has been paid for on behalf of the applicant. Since the learned advocate representing the applicant is unwell. Next paragraph. However, no one is representing the respondents. In order to grant one more chance to the applicant, hearing of this matter stands adjourned till 14 June 2024, when it will appear under the same heading. Next.
Item number 73.
But I appear on behalf of the respondent number 5.
Application. Order of 5th February 2024, dismissed for default, Your Lordship. Petition affirmed on 8th of February, Your Lordship.
But I am opposing this one. But why I will tell your lordship.
May I file the affidavit of service?
Whether your client is in court.
May I kindly come to paragraph 4, 6 and 7. Otherwise, I wouldn't have said. এইসব লাগবে না রে, এতে কি হবে? Generally, I don't oppose. Paragraph 4, the last line, the respondent number 5 had served her affidavit in reply. We have not served the affidavit in reply. We have served the affidavit in opposition.
So 1, 2, 3, 4 and 5 all have used affidavit in opposition.
Yes, we have used.
5 is CSC.
No, 5 is my client one.
1, 2, 4 had filed affidavit in opposition.
May I kindly see your lordship's order of dismissal that my lord has recorded it.
Yes.
Now, my lord will kindly come to paragraph. Kindly come to paragraph 6, the reason given. Kindly see paragraph 6, the reason given. The fourth line, my lord. Third line I'll read. When the concerned writ petition was taken up on paragraph 6. Well, my lord, kindly remember that there are the continuous litigations are going on between the parties. When the concerned writ petition was taken up on 5th February, yes.
Yes.
When the concerned writ petition was taken up on 5th of February 2024, the advocate for the petitioner could not reach this honorable court in time. That's it.
Yes,
now, my lord will kindly come to paragraph 7. Paragraph 7, second line. May I read, my lord? That the advocate was appearing before the another bench. That the advocate was appearing before the another bench of this honorable court when the concerned writ petition was taken up by this honorable judge and has passed the above stated order. Kindly see the order dated 4th of December. There is an advocate on record. There is a junior counsel. There is a senior counsel who is appearing.
Yes, yes. The application being can 1 of 2024 is for recall of the order dated 5th February 2024 passed by this court on the connected writ petition. Stop. The application is heard in presence of the learned advocates representing the petitioner, comma, CESC and respondent number 5. Stop. The learned advocate representing, you are representing respondent number 5. The learned advocate representing respondent number 5 has opposed the prayer for restoration, prayer for recalling of the order dated 5th February 2024. And in support of the same, attention of this court has been drawn to the averments made in the application in paragraph 4, 5, 6, and 7. Stop. Next paragraph. On perusal of the application, this court finds that an explanation has been offered that on the day and at the time when the writ petition was dismissed, the learned advocate for the applicant could not reach the court, which appears to be satisfactory explanation. Stop. Accordingly, the order dated 5th February 2024 stands recalled. The writ petition is restored to its original file and number. Stop. The application being Can 1 of 2024 is allowed and disposed of.
I am grateful.
Affidavit of service উপরে বলা আছে দেখো তো, every service filed on behalf of the applicant is taken on record.
I'm grateful. Sometimes we have to say.
Yes, yes.
I'm grateful.
That I understand. কি হলো? আর কিছু নেই? কি অ্যাপ্লিকেশন শেষ, আর কোনো ইন্ডিকেশন নেই লিস্টে আর কিছু ধরা হবে? বাবা, এরকম তো জানা ছিল না। না, বলা আছে কি অ্যাপে কন্টেন্ট গুলো ধরা যাবে? কোনো ইন্ডিকেশন আছে? বলবে তো, তাহলে তো কন্টেন্ট গুলো আমি ইন্ডিকেট। তারপর আবার কন্টেন্টটা বলা নেই। ডাকো। কন্টেন্ট গুলো নিয়ে নেওয়া যেত, খেয়াল করে নিন।